for like,
You and Daniel
what's the
both.
difference between
I'm
a dark
sorry, I
navy
have to
blue
go to
and
the
black?
bathroom.
This cream shirts
Dark
competition.
navy blue.
Yes.
Lots.
A
What's
lot.
wrong with
Like
gray?
one
Navy
day.
blue and one black.
So,
Hey,
Taylor
let's
has
take it all the
this
way down
weird
the
thing
spectrum,
about
come on.
gray suits, because did you want us to match when we were partners?
Yes.
Taylor was my partner. Taylor's the best partner, but like we would get into fights about
But-
like suits all the time.
Yes.
It
Well,
was,
I
it was, like,
bought this gray
remarkably
suit, my
inconsistent.
first suit that I bought in like 5 years, before junior year, and I was like, you have to get a gray suit.
I never
It's like,
did.
absolutely not.
I bought every color but gray. I
Really?
think-
Did you do it on purpose?
Black.
A blue suit, like a navy blue,
Navy blue. I bought a new black
a
one.
black suit, which turned out I bought another black suit, and then we did match most of
Most
senior
of
year,
yeah.
my senior year.
And then I just like from there stopped buying full suits and started just buying blazers. Now I have like a green one, a red one, a tan one, 2 tan ones,
And a gray one.
and a gray one. I love this blazer. I get to wear it nearly enough.
You should get, it's a good shape. You should get pants that match.
I don't know how to do that anymore. This is like a couple seasons old. I don't know how it works.
Just look up,
Who's signing?
gotta exist somewhere.
Chief Justice.
Chief Justice.
Well, Chief Justice does not time.
Alright.
No time!
Would anyone like me to teach
I have
them how to
religious
sign and
exemption.
volunteer time? So that
Aaron
they-
has a little consumption.
I'll do it. It's pretty easy,
No,
so,
I have converted.
um,
Can I sit right here or should I go over there?
yeah, why don't you
can say, as
sit?
long as, the important thing is that they can.
I
you
want
can sit- you're
everybody to be
welcome
able to
sit here.
see you.
Yeah.
Okay, I'll sit over there.
So the deal is, are you doing 3 minutes for both?
We didn't even talk about it.
You should have talked about this, I'm just
Well,
saying.
we're not gonna be
I'm
partners
just,
for the
I'm
semester.
just saying.
Just
Stop
make it
yourself.
two. We'll both
Okay.
put 9 o'clock.
So
Stop
the
myself.
thing
Stop
about
yourself.
petitioner is petitioner only gets 9 minutes.
Okay.
So what you do is you give them, right, when they get down to 8 minutes, give them the 8 minute, and you flip it every minute.
Okay.
Then you'll have 30 seconds, 10 seconds, and time.
Got it. We will not hate you if you miss
Yeah.
a minute.
Yeah, no, that happens all the time. The important parts is like 1 minute and 30 seconds. Those are really important that they know because
Yeah.
then their time's almost
I
running out.
wouldn't know.
Respondent gets 10 minutes because they don't have a
Because
rebuttal.
you're not,
So the way it works is each team gets
Never
20
mind.
minutes holistically. So, you know, petitioners will set up with 9, 9, and 2. Respondent has their rebuttals, which is do 10 and 10. I have seen people do 11 and
It's-
9.
That's
It's
just
always
weird.
That's kind of strange.
Okay.
Don't-
It makes me uncomfortable.
Yeah, just for everybody,
Yeah, it makes
don't
them
do
really
that.
uncomfortable,
It's
so.
weird.
Why is that weird?
Because you don't need 11.
Well, because it's
Like unfair to your
okay. You want to look.
a minute away from
Yeah.
your
Yeah. So basically,
It's
you
20
want
minutes
to look
I
like.
see, okay, gotcha.
You don't want to look like one half of your partnership is like the powerhouse.
I see.
Like you can't have one person be the mitochondria and like the other be like the endoplasmic reticulum, right? Like you have to have you should be like a solid wall. No weak links.
Got it.
Please tell me you actually know what that means, and
Yeah, I don't know what ER does, but I do remember what mitochondria does.
Anybody ever watch the show The Weakest Link?
Those gray jeans.
these are good.
British lady?
so can I stand up? I can leave it over around and
Oh,
let you go.
I am 2 pairs of gray jeans.
Let's please be
That's
done.
not what I'm jealous of.
Yeah, this.
Oh, by the way,
technically,
I
everyone's
wore my
making-
color suits
Yeah, we
the
can have.
entire week and nobody said a thing.
You're judges.
But
It's not move part.
oh, we're not going till 2, like furious.
Yeah, okay, cool.
Yo, judges.
Yeah.
Judge the thing.
No.
The vegan one ready?
Chief Justice, Associate Justice, and may it please the court. My name is Brenton Brown, and along with my co-counsel, Ms. Erin Mesha, represent petitioner, Honorable Billie Jean Denoff, in the case at bar. I will be addressing the standing and the First Amendment issues, while my co-counsel will be addressing the 14th Amendment issue. Your Honor, before I begin, may I request 2 minutes for rebuttal?
Granted.
Would you like a brief recitation of the facts?
Sure.
In 2010, the state of Olympus enacted the Voter Identification and Anti-Voter Fraud Act. This act was intended to bring more legitimacy to the election process within the state. It mandates that those seeking to cast a ballot bring forth the photo ID which matches their respective identities. Honorable Billie Jean Denoff sought to cast a ballot in the 2012 general election, but was denied due to her name having been changed because she was recently married. The 2 questions today before this court are whether a petitioner with a personal stake in the outcome of a decision can be denied standing, and whether the state of Olympus can erect barriers which interfere with the most sacred of American rights, the right to vote. We respectfully ask this court to reverse the decision of the lower circuit for the following 2 reasons. First, Mrs. Denoff satisfies Article 3 standing requirements, and second, the Anti-Voter Fraud Act is an unreasonable restriction on voting. On to my first area of analysis. Mrs. Denoff satisfies Article 3 standing requirements. As the Third Circuit found in Time Warner Cable Inc. versus Hudson, the irreducible constitutional minimum of standing contains 3 elements: injury in fact, causal connection, and redressability. On that day in 2012, Mrs. Denoff did suffer an injury, which was her being denied the right to vote. And this injury is directly traceable to the Anti-Voter Fraud Act.
Is it really traceable to the act, or is it traceable to her refusal to bring her ID?
Your Honor, it is traceable to the act because just because Mrs. Denoff made the life decision to get married should not disqualify her from the voting process. And this was something that can happen to any citizen if they were to just say they wanted to get married on any particular day, and there just so happened to be an election which occurred the next day, and they would not be able to vote. This is an unreasonable restriction on voting, Your Honor, because Mrs. Denoff should have been able to bring some form of documentation. She had a marriage license, which she got the day she was married, which should have been allowed for her to vote on that day in 2012.
Why didn't she just vote, I don't know, even a day earlier?
Your Honor, Mrs. Denoff did not vote a day earlier because she wanted to vote on the election day. As the record notes, Mrs. Denoff wanted to make sure that she had all the information, as much information as possible on each candidate to make sure in each issue so that she would make the best informed decision come election day. And she is she likes to vote on the exact election day because that is something she's always done. This court has found that whether a plaintiff in Arlington Heights versus Metropolitan Housing Development Corporation, whether a plaintiff has alleged such a personal stake in the outcome of the controversy as to warrant his invocation or their invocation of federal court jurisdiction and to justify the exercise of the court's remedial powers is something that is important in regards to standing. Mrs. Denoff's injury, which leads me to the third prong of the analysis, redressability, can be redressed because Mrs. Denoff is an elected official, and Mrs. Denoff's being denied the right to vote on that day in the subsequent YouTube video, which
is it likely, in your opinion, that, because this is not a traditional redressability case, right? You would agree, this is not your traditional case where it's easily redressed. We can't go back and change and give her the right to vote in that election, right?
Correct, Your Honor.
Yeah, so your argument is that it's something that could happen again. So we should allow it because to not allow it would be, it'd be allowing something that's easily repeatable yet avoiding review, something like that.
Your Honor, her being allowed to vote on that day can't be redressed because it's already happened,
Mm-hmm.
but the electability aspect can be redressed. Mrs. Denoff's electability was diminished by having this law deny her the right to vote.
How can we, I mean, like, you're asking us to unring a bell, right? Her electability, the YouTube video, or it's not a YouTube video anymore, but the quote of her blowing up at that reporter is out there. We can't, we're the Supreme Court, we're still not that powerful. We can't go out there and make them stop sharing the link, can we?
No, Your Honor, but for the citizens within the county in which she resides, that video and the subsequent decisions by this court would have a huge impact because if this court were to overturn this law, then Mrs. Denoff's blow-up perhaps would be justified because this court remediated the circumstances which caused that.
Okay, now let's go way out of proportion, use a historical example. Barry Goldwater lost the 1964 presidential election in part because he voted against the Civil Rights Act. Should we upheld the Civil Rights Act in Katzenberg, which is not in the record, so don't address it. But would Barry Goldwater have had standing to challenge the law saying that his vote, the fact that he was forced to vote on that matter, affected his electability in the 1964 election?
Your Honor, do you repeat your question?
Yeah, so Barry Goldwater lost the 1964 presidential election, in part because his vote against the Civil Rights Act. Now, the Civil Rights Act was later challenged in court, but not by Barry Goldwater. is it your contention that Barry Goldwater would have standing to challenge the act because it diminished his electability?
Your Honor, that would be a completely different set of circumstances. And the Civil Rights Act is something which is entirely separate from this law.
Yes, it is, but I mean, in the abstract, he voted for or against a law. That law and his actions and his actions alone diminished his ability to be elected. It is your argument, as I understand it, that because Judge Denault expressed an opinion after not being allowed to vote, and that opinion, and her opinion alone, reduced her electability, that she has standing to challenge a law. Is that your contention?
Your Honor, my contention is that the Anti-Voter Fraud Act is an unreasonable act which should have contention from different members of society who will otherwise be disenfranchised from the political process. The Civil Rights Act is something which gave people more rights. This is restricting rights.
Okay, let's use another example. A few years ago, Todd Aiken of Arkansas commented on rape laws. And this public comment, reduced his electability and lost him the U.S. Senate race in Arkansas. Would he have had standing to challenge the rape laws in Arkansas because his statement on them reduced his electability?
Your Honor, Mrs. Denault has standing not only because of the injury in fact and the cause of the action, and the redressability is not just about her electability, but it's also about the fact that she won't have to run into this occurrence again in the future if she were to get divorced, per se. Mrs. Denault got a divorce a few days before an election, she would be in the exact same set of circumstances. This is to prevent the same occurrence from happening to Mrs. Denault in any set of circumstances which would otherwise deny her or restrict her access to the ballots. And the Anti-Voter Fraud Act is not only she not only has standing, but this law should be judged by its merits, which is my second point of analysis, because it is an unreasonable restriction on voting. Your Honor, restrictions on speech in a non-public forum to be valid, as the court found in Minnesota Majority versus Mansky, 8th Circuit, must also be reasonable in light of the purpose which the forum at issue serves. We are to judge this law by its merits and how reasonable it is. And it is not reasonable to close most of the election polling locations. It is not reasonable to have people drive huge distances to get to the ballot, and it is not reasonable to deny someone the right to vote just because they just so happen to be married 1 day or 2 days before the election. It's because of these reasons that we respectfully ask this court reverse the decision of the 14th Circuit.
Thank you, counsel. Give me the name ready.
Chief Justice, Associate Justices, and may it please the Court. My name is Erin Masha, and I argue on behalf of the Honorable Billie Jean Denault, petitioner in the case at bar. The question before the Court today is whether the legislature of the state of Olympus may attempt to combat a minuscule amount of voter fraud by enacting legislation that places a barrier between the most vulnerable citizens of Olympus and their most sacred and protected American right, the ability to participate in the electoral process. The incorrect decision of the 14th Circuit Court of Appeals must be reversed for the Verification Act. The Voter Identification Act not only suppresses speech and voting rights, but also violates the Equal Protection Clause of the 14th Amendment for two dispositive reasons. The first is the Voter Identification Act creates an injury for only certain groups, and the second is the injury created by the Voter Identification Act substantially interferes with the integrity of the electoral process. Looking at my first area of analysis, Your Honors, the Voter Identification Act creates an injury specifically for certain groups. Now, if we look at the standard that this court should consider this law under, we look to Burdick versus Takushi, which cites Anderson versus Elbreezy, which talks about a flexible standard test. A court considering a challenge to a state election law must weigh the character and magnitude of the asserted injury to the rights protected by the First and 14th Amendment that the plaintiff seeks to vindicate against the precise interest put forward by the state as justifications for the burden imposed by its rule, taking into consideration the extent to which those interests making it necessary to burden the plaintiff's rights. We can see that this is an unjustifiable burden on not only the First Amendment rights of petitioner, but also the 14th Amendment rights. Under this standard, the rigorousness of our inquiry into the propriety of a state election law depends upon the extent to which a challenge regulations burdens the First and 14th Amendment rights. Thus, if we have recognized that when those rights are subject to severe restrictions, the regulation must be narrowly drawn to advance a state interest of compelling importance. And we contend that this is a severe burden on specifically Miss Billie Jean DeNolf's 14th Amendment rights because she was not allowed to vote as a similarly situated person would have. If we look at the groups that Voter Identification Act disadvantages, we can look specifically to the part of the law that harms them. That states all eligible voters must present to state election officials a valid photo identification bearing the photograph and current name and address of the person to whom it was issued and containing an expiration date.
So, counsel, is your issue with the law the photo identification part or the fact that it must contain the legally correct name?
Your Honor, both. These create, basically, the point is that not only the photo identification part, as well as the correct name, but the current address means that it disadvantages anyone who does not, anyone who would have a possibility of changing their name or address. This would include women, indigent voters, the nuns mentioned in the case problem, transgendered persons, people who rent their property. Really, the only person who would have stability under this law would be home-owning males. And therefore, this law discriminates against already vulnerable groups present in Olympus and bars them from the ballot box.
So you think, would this law be constitutional if the state created some method that allowed people with these issues to cast a provisional ballot and given a reasonable amount of time, maybe greater than the 48 hours currently listed, to prove they are who they say they are?
Absolutely, Your Honor, and that's sort of gets into the other problems with the law, that the waiting period is too small. 48 hours is not enough time to get an acceptable identification. There are no exceptions. You cannot present any other form of identification, no birth certificate.
More recently, I know that this is outside the record, but recently, in issues with laws in Texas and Wisconsin, federal courts have, rather than striking down the whole law, have required that the state make attempts to make their law less of a burden. Is that something you want here, or do you want the whole law to be stricken down?
Well, Your Honor, that would be helpful. However, we contend that the entire law is problematic. Not only for the 48-hour time period that would restrict a potential voter, but also because of the way that Olympus carries out its issuance of IDs and its elections. There are only 2 operating centers in Olympus that can issue valid photo identifications, and some people in Olympus would have to drive more than 200 miles to get to those centers. And with a 48-hour time period, this is simply not feasible. Moreover, none of the photo identifications that would be acceptable under the law are free of charge. Specifically, Olympus stopped issuing free IDs with the issuance of the Voter Identification Act. They had done so before, but chose not to with this act. And that brings me to my second area of analysis, that the voter identification law actually harms the electoral process because it invidiously discriminates against certain groups. And we can see, particularly with that provision of stopping issuing free IDs, makes it so any indigent voter or any person with a changeable name and address would be disadvantaged by this law. If we look at
Counsel, doesn't this $25, it's a fairly small amount, doesn't it help to pay for the electoral process? Because my reading of the case says that for people unlike your client, it only takes about an hour for any of these IDs to be issued. So that kind of efficiency seems to me fantastic. So doesn't the state's interest in efficiency and its proven benefits within the case problem outweigh that cost?
You're right, it might seem as if Olympus is interested in efficiency. However, based on parts of the law, it's unclear. Having only 2 centers issuing identification wouldn't speak to having an efficient way for most people to get identifications. as well as the fact that there are only certain IDs that are accepted, which means that only people who have access to certain types of IDs would be able to vote. While you're right that some parts of the law would enhance efficiency, it does so at the cost of the electoral process. If we look at the effect of this law, even one of the co-sponsors, the Democratic co-sponsor for this law, specified that this might affect certain parts of the population to include low-income voters, women, and those with religious objections to being photographed. However, they weren't entirely certain how that would manifest itself. However, if we look at page 3 of the record, the amount of voter fraud over a 20-year period in Olympus, over all ballots passed, was 0.00001%. That is not enough in any specific election to swing the results of the election. However, the Voter Identification Act would, if it had a large enough effect on certain parts of the population.
So say we gave away free IDs again, and we created more places for people to get IDs, and we increased the days for the provisional ballot. Are there any more problems with this law?
Well, Your Honor, we would contend that the types of IDs need to be expanded for a student ID should be acceptable as well. And that if we look at the way that the election was carried out, we're not entirely sure why.
I worry though that with some of your requests, that you're asking the judiciary to write Olympus election law for them.
No, Your Honor, and to clarify, we would say that if it was possible to strike parts of this law and make it constitutional, then we would be fine with that. However, we don't think so, particularly because of the way it was enacted. We believe it was enacted with invidious discrimination. Not only because they stopped issuing free ID cards, but also because some of the comments made by the president of the Republican Party of Olympus and his intent to stop certain parts of the population from reaching the ballot box.
I mean, isn't that just a reflection of his belief, correct or incorrect, that a number of ineligible voters were voting in Olympus?
Your Honor, yes, however, it's an incredibly small proportion and not enough to swing any given election. This law, however, does remove the ability of some parts of the population, whole sections of the population, to vote in a way that could compromise the results of an election. And it's for these reasons we urge this court to find in favor of petitioner and overturn the erroneous ruling of the lower circuit. Thank you.
Thank you, counsel. Mr. Barron. Actually, give me a minute. No, I'm actually. Good.
Chief Justice, and may it please the court, my name is Josue Barron, and along with my co-counsel, Kristen DeWild, represent the respondent, the state of Olympus, in the case of Barr. I'll be addressing the standing challenge, while my co-counsel addresses the First and 14th Amendment challenges. The question before the court is whether life's everyday happenstances warrant standing before this court, which this court should find that answer to be no, and affirm the decision of the 14th Circuit Court of Appeals for the following two reasons. First, that Billie Jean Deneau's injury was on her own accord and not caused by the voter law. And second, that there is no proper redressability for Ms. Deneau. And on to the first area of analysis. Your Honors, the case of controversy requirements set forth in Lujan v. Defenders of Wildlife provide the most appropriate standard for standing. The irreducible constitutional minimum of standing contains three elements: injury, traceability, and redressability. On to the first element of standing, injury. Defined explicitly in Lujan, that first the plaintiff must establish that an injury, in fact, an invasion of a legally protected right, which is concrete and particularized, and also must be actual or imminent, not conjectural or hypothetical. Your Honor, the injury in which Billie Jean Deneau claims to have injured was on her own accord. There was multiple early voting days where she could have voted but decided not to.
Well, petitioner argued that that she was taking as much time as she wanted. I mean, isn't that a voter's right? If you turn in a paper a minute before it's due, it's still on time, isn't it?
Yes, Your Honor, but there, within the record, there's no indication that the public officials failed to inform the voters, including Ms. Denofa, about this act. Thus, she could have moved up the day she was going to get married. She knew the date that she was going to be married to Mr. Denofa.
But I mean, the law doesn't say, the law says you have X amount of days to vote. It doesn't say you have X amount of days to vote unless you get married prior or need a name change or whatever, then you only have a certain amount. It says you have these amount of days to vote.
Yes, Your Honor, and we contend that even though Billie Jean Denofa does have her option to choose whatever day she does want to get married, that shouldn't allow this court to overrule the decision, because life instances happen all the time. And it is unfortunate that Billie Denofa did get married a day before, but those certain situations do not
I
dictate.
think it's unfortunate. It's a happy thing, marriage.
I mean, unfortunate that she was denied her right to vote, but it shouldn't dictate the way the election procedures are, Your Honor. Which leads me to the second element of standing, which is traceability. The petitioner claims that
Wait, you're saying that this is all her fault that she didn't get to vote. Once again, do couples now have to choose what day that they want to have their wedding based upon elections? Is that a thing that everybody has to take into account now when they're getting married? Oh, I can't get married around election day because I won't be able to go vote in the state of Olympus. Is that a thing?
No, Your Honor, but with the conclusion and logic used by the petitioner, it would insinuate that if the election day was moved back a couple days, then this law would be appropriate. But, Your Honor, the fact that she was married does not change the circumstances that things in life happened and that she decided to get married. But it doesn't mean that the state of Olympus has to account for every single
Counsel, I
instance.
mean, many states, Olympus I imagine included, allow any number of exceptions for people. People's age 65 and older are probably mailed ballots. For people who are out of state, individuals who are overseas get mailed to them ballots. So how difficult would it be for Olympus, who's saved all this money supposedly by closing all of these places to vote or places to get IDs and requiring people to drive hundreds of miles, you're saving all this money, how difficult is it for you to create just one or two exceptions for people whose name changes right around election day?
Your Honor, if there were exceptions made to this act, it still would not guarantee standing for the petitioner. Going on to the traceability, that second, the petitioner must show that there was a causal connection between the injury and the act being challenged. Your Honor, petitioner states that because of the act solely was the reason why Ms. Denofa was denied standing. But, Your Honor, the petitioner also concludes that the reason why she was denied her right in this case is also because she lost the election. But, Your Honor, doing her own election was her own volition. And onto the causation aspect.
But yeah, I agree. I don't know if I totally bought that argument when the petitioner said it, but it seems to me her injury in terms of being unable to vote is very clear. She went and attempted to vote and was unable to do so. And the reason she was unable to vote was because of the law.
Your Honor, the law was in place in which may have deterred in a certain way, but in similar circumstances, people that forget their IDs.
Deterred, I mean, use whatever word you want. She attempted to vote and was unsuccessful. And the reason she was unable to do, if she had attempted to vote in this fashion prior to the passing of this new law, would she have been able to vote?
Your Honor, she, I don't know specifically the answer to your question, but individuals who forgot their IDs at home, who grew a beard,
Then should we remand to the, since we don't know this, should we remand to one of the state courts of Olympus to let them decide what the law said and says?
That may happen, Your Honor. I mean, this court may do that, Your Honor, but for standing purposes, it's for this court to decide whether or not this case is justiciable, for this court to decide, Your Honor, or for courts to be the proper remedy.
And your contention is still that it's not?
That is for standing wise, no, she does not have standing for this court to give a remedy, Your Honor.
I want to hear your argument about redressability.
Your Honor, petitioner claims that it is redressable, that she'll be able to get that vote back, and that she might run in future elections. Also, that when she gets divorced, that again her right will be denied, the right to vote. But Your Honor, redressability is explicitly stated in Luan versus Friends of Wildlife, is that third, it must be likely as opposed to merely speculative that the injury will be redressed by a favorable decision. Your Honor, being divorced particularly is not something that happens in an instant, and it's merely speculative.
Well, I mean, with the divorce rate at whatever, between 40 and 50%, it's not speculative that somebody's gonna get divorced. It's not speculative that somebody might get married or divorced around election time. Clearly, somebody got married around election time. Olympus is a big state, so why is that speculative? Doesn't divorce in our current society seem like a likely occurrence?
For Billie Jean DeNova, that is clearly uncertain, Your Honor. Other individuals may get divorced, but Billie Jean DeNova, there is no indication that her marriage is going bad.
So her right to vote should be dependent on whether or not she has a happy marriage.
No, Your Honor, but this was one of the conclusions of redressability that the petitioner brought up. Also that redressability that she would have won the election if the video wasn't posted. Your Honor, Billie Jean DeNova has not declared that she will be running again, and also stated in Luan.
I follow elections. There's always the photo op, right? As the candidate goes into the ballot to cast their ballot, the cameras are on them, and that's kind of like an important thing. If she's going to run again, isn't it kind of shouldn't she be able to expect that kind of opportunity, or will that be denied to her just because of her marital status?
Your Honor, that right will not be denied in the future.
How do you know?
Because on page 8 of the record indicates that she's already filed paperwork 1 day prior to election day. And since it takes 10 to 14 days for ID to arrive, 4 years has accumulated and she has already received her identification.
Okay, so if she gets divorced, as petitioner said might happen, she must then be absolutely certain that she's not within 10 days of election day when she files those divorce papers or gets her name changed.
Yes, Your Honor, I completely agree. When that instance happens, she will clearly, for that case, would have standing. But onto the...
That's what happened here.
No, Your Honor, she is not divorced.
She's newly married.
But
So yes, Your Honor.
he's trying to say it's the same situation. If she was to get divorced and get her name changed back right before election day, we're right back in the same position that we are right now with the same case. And the only instance is the status. She was married, now she's divorced, and before she was single, now she's married. What's the difference?
Your Honor, prior to this act, she had proper identification to vote. She was able to go through the proper legal means to vote before this act, and even when this act was passed, the 14 days during election day did not hinder her. So this is not the sole cause of the act is not the sole cause of her being denied the right to vote, Your Honor. It's merely life's everyday happenstances, and that's what happened in this case. And for all this reason, we respectfully ask for this court to affirm the decision of the 14th Circuit Court of Appeals. Thank you.
Thank you, Counsel. Mr. Wild?
Chief Justice Ledford and Associate Justice, may it please the court. My name is Kristen DeWild, and I address the issues raised under the First and 14th Amendment, representing the state of Olympus, respondent, and the case at bar. The question before the court today is, must the state of Olympus enact a statute so broad that it may be incapable of enforcement? In which the answer is unequivocally no. This court should affirm the decision of the 14th Circuit Court of Appeals and uphold the Voter ID Act. In response to petitioner's claims, it is unclear if the petitioner is bringing forth a claim of discrimination under the Equal Protection Clause or bringing forth a claim of burden. Therefore, I will address both in two parts of my argument. First, that the Voter ID Act is not a severe or unjustifiable burden under the First and 14th Amendment. And second, the Act affects similarly situated persons and groups the same without discrimination under the Equal Protection Clause. As cited in Godoldig versus Aiello, this court held in Dandridge versus Williams that a state is not required to choose between attacking every aspect of a problem or not attacking the problem at all. The state of Olympus has chosen to address the problem of voter fraud and public confidence in the election process, as found on page 2 of the record. Petitioner poses today that the fact that Billie Jean DeNolf was denied the right to vote because of life's peculiarities, such as a name change the day before an election, that the state's voting process imposes a heavy burden. Yet, in the state of Olympus's enactment of a voter ID law, the state of Olympus cannot be expected to account for every minor life happenstance. Doing
Would you
so,
call marriage a minor life happenstance?
Your Honor, I would not call marriage a life happenstance. However, I would
I mean,
call
we've
marriage.
held many times that marriage is a fundamental right. So you're asking us, with respect, counsel, to choose between two fundamental rights here.
No, Your Honor. Marriage itself is not an ordinary life circumstance. However, getting married the day before an election is one of life's happenstances and something that is a rare situation that doesn't occur. However, the state of Olympus
It doesn't,
in
a rare
enacting
situation that doesn't occur.
does not normally occur.
Okay.
And in enacting a voter ID law, the state of Olympus cannot incorporate all kinds of life happenstances into its law, which is why it creates other means of being able to vote, such as an early election process or such as a provisional ballot. Article 1, Section 4, Clause 1 of the United States Constitution provides the states may prescribe the times, places, and manners of holding elections. When determining if a state's regulation on elections is a burden, petitioner does use the correct test as established in Verdict versus Tagashi, which is the flexible burden standard. As cited in Verdict versus Takashi, this court held in Storer versus Brown that states must have a substantial regulation of elections in order to maintain order. And it held again in Anderson versus Celebrezze.
Okay, let's do a general burden analysis on this problem and compare it with Takushi, because in that case, you've got write-in candidates who, let's face it, are probably not going to win the election. You're not facing a lot of voters here that are put out of place because they can't write in a candidate. There's not even saying that they're going to write in the same candidate. And if they were, as we pointed out then, there are plenty of other avenues for it. But here, it seems to me, and petitioner brought this up, that there are a large number of people that are prevented from voting by this law. So a large number, maybe hundreds of thousands of people that will not be able to vote because of this law versus the 0.00001% of fraud you're preventing. At what point does one balance out the other?
Well, Your Honor, that does bring me to a point that I wanted to make, that this court has repeatedly upheld in cases such as Anderson versus Celebrezze and Crawford versus Marion County Election Boards, as well as Common Cause, that when looking at the burden of proof and the number of people affected, the state has to put forth no amount of people that were actually affected by the law in order to justify its compelling interest in regulating election. It could be one person found of voter fraud, it could be zero, but the state has an undeniable...
So that one case of voter fraud outweighs 200,000, the
Yes,
fundamental
Your
rights of
Honor,
2,000.
this court has held in Anderson that it does not matter. In fact, the Indiana law and Crawford could show no one
So why
that
should
no
we
instance
overturn,
of voter
if
fraud.
that's what Anderson says, I may not like it,
And Crawford.
why should we not overturn those decisions?
We should not overturn it because the state has a continual and undeniable interest in regulating elections and promoting voter integrity. Voter fraud comes with two parts, one in preventing the fraud and one in remaining public confidence in the election process, which is a psychological interest the state wishes to protect. Now, a petitioner asserts that there's two main burdens on the numbers of people here, the name change and the address change. A state must be able to implement that an address is verifiable for the mere state that they must be able to know that the person within their state is eligible to vote in their state. And the record speaks on no amount of numbers that are actually affected by this law, nor the record...
Okay, Counsel, can you walk through with me the process of voting in Olympus as it currently stands? Because you want to guarantee that the people that are voting are eligible to vote. The person makes a voter registration card, sends that in, it's sent back, and they get a card. All of that process is done without ID, without any verification of they are who they say they are and where they live. And then they must present an ID at the polls which matches that information.
Well, Your Honor, now when obtaining the photo identification, you do have to present various forms of photo ID just to get the voter registration card. Whereas before, you only had to present things such as a utility bill. The state of Olympus has implemented the photo ID requirements that you have it when trying to vote as well as getting to the polling place itself. However, there is no stipulation in the record that the address change presents any problem, and in fact, by
I'm
petitioner's
not
reasoning.
so much, I understand what you're responding to petitioner, but I guess my concern is more along the lines of you want to verify the integrity of a process, half of which takes place without any verification. Right. There is no, in the paper process of the voter registration card, there is no verification of that except for the ID which is presented at the polls.
You have to bring forth ID along with multiple forms of other identification. Therefore, you have to have a valid photo ID along with other things that validate
So-
as well, such as a birth certificate.
Oh, so when you go to the polls, you have to have both my
Not
Olympus
when you go
drivers.
to the
Oh,
polls,
okay, okay.
when you register to vote.
Okay.
Yes, Your Honor. Additionally, Your Honor, the petitioners bring forth here that the name change constitutes a burden. However, while Burdick was only addressing write-in ballots, Burdick did make the point, and this court held, that reasonable regulation does require voters to act in a timely fashion if they wish to express their views in the voting booth. Therefore, petitioner, in this case, Billie Jean DeNolf, could have acted in a timely fashion and not have been prevented to vote. And this timely fashion in Burdick did occur before the actual day of election because they had to get their persons on the ballot before the day of election and could not just write them in. Therefore,
Okay, so, I understand where you're going, but you got about 2 minutes left, so I'd like you to talk for a minute about petitioner's argument with regard to this being a poll tax. It seems to me you're charging people $25 just to vote.
well, Your Honors, Harper, in which the poll tax was raised in the issue, Harper was a direct fee associated with voting. However, this court has never found that indirect fees of voting constitute an invidious discrimination or burden under the 14th Amendment.
But
In
you're,
fact,
Say we do now.
well, Your Honor, you would have to overturn all precedent in Crawford.
Why not? Do you still lose?
No, Your Honor, because the mere fact voting comes with regulation and voting comes with costs. If you want to vote, you have to take off work. If you want to vote, you have to drive and use your gas money.
to give you a break from my counsel's questions, my Associate Justice's questions, but under Harper, it seems to me this is a direct cost because this is a cost of the voter ID itself, the ID which exists solely to vote. That voter ID does not give you anything else, doesn't give you the right to drive, to have a gun, to do anything but vote, and you charge money for it. So it seems to me it's a poll tax.
No, Your Honor, this is comparable to the birth certificate requirement in Crawford and Common Cause Georgia versus Phillips, in which in order to vote, it was required to present your birth certificate. A birth certificate does require a cost to it, does not come free. However, this was not found to be a poll tax, and in both instances, the Supreme Court and the Circuit Court in both these instances held that it was not a poll tax. And in my last 30 seconds, I would like to address that this is not invidious discrimination. Discrimination is, the 14th Amendment can be addressed in discrimination against groups. However, Billie Jean DeNolf does not have the right to address discrimination based off minorities and only has the right to address discrimination based off gender under the Equal Protection Clause, which is not invidious discrimination and only held to an intermediate scrutiny in which this state passes. Thank you.
Counsel? Ms. Maisha, your rebuttal? Oh,
These are the worst timers.
oh, wow. There we go.
Good?
Yeah.
Awesome. May it please the court, in my brief time of rebuttal, I would first address the standing issue and then move on to the 14th Amendment issue. Your Honors, looking at the standing issue, there is not redressability in the way that there normally would be redressability in a constitutional law case. However, as my co-counsel mentioned, this is a harm, an injury that could be repeated if Miss Billie Jean DeNolf were to get divorced. And the date of her divorce, just like the date of her marriage, should not be subject to when an election is. She should be able to have her constitutional freedom to vote, as well as engage in association or disassociation as she may choose. Now, moving on to the 14th Amendment portion of this case, this law does not promote the integrity of elections. we can the state of Olympus could handle identifying voters with a less stifling law. And specifically the provision that takes out that Olympus, up until the enactment of this law, did issue free identification cards. There was no reason to stop doing that unless the enactment of the law had a subsidiary purpose to motivate some portions of the population to stay away from the ballot box. If we weigh the interests, if we weigh the effects of this law, there was an incredibly small amount of voter fraud, even prosecuted, not necessarily even convicted in Olympus over a 20-year period. And none of those instances were ever even near affecting an election. However, what this law does is puts whole segments of a population at a disadvantage to even get to the ballot box. And for this reason, this court should overturn the erroneous ruling of the lower circuit. Thank you.